Welcome to our podcast, Decoding Gaming Law. My name is Franklin. I'm here on behalf of CSB Group, powered by Sigma. And today we will be continuing the discussion on litigation in the gaming industry. Today we have once again Dr JP Gauci-Maistre. This is part 2 of the litigation part of the gaming world. Last time we discussed insolvency proceedings, we discussed as well the recognition of foreign judgments, and today we have some more developments. So JP, over to you.
Thanks, Franklin. Good to be back. Pleasure.
My pleasure as well.
Last time was extremely interesting. And the question is, what hasn't happened since we last spoke some 6 months ago? So I think it's been a bit of the whirlwind has continued.
Yes.
That's the truth. So good thing is this time we can just dive right into it and pick up where we left off last time. Do away with introductions. So since last time we had 2 very important decisions in Malta. First order decisions, which although there were decisions like them prior to these 2 decisions, this time the decisions were much more studied. They were in depth. They reconfirmed what the courts have been saying, what a decree and the previous court decision has stated, that foreign judgments, in this case they were particular to Austria, should not be recognized and enforced in Malta with respect to the player claims. And just to touch on where I left off, these tend to center around players requesting to get their money refunded that they lost playing with a Malta licensed operator from Austria in this case.
And the Austrian courts
Austrian courts ruled in favor of the player, said you have the right to recover your money, but when they asked for a warrant to be taken out in Malta. They got the warrant taken out in Malta to protect their interests against the Malta gaming operator. Then the Malta gaming operator, 2 of them, filed cases to say that the warrant should be revoked, and that no decisions of this type should be recognized and enforced in Malta. And what was interesting about these 2 decisions, in my view, is that previously another first hold had dealt with it and said, no, they should not be recognized. A decree in proceedings, so like not a final judgment, but just a decree during the course of proceedings which have to do with a creditor's, with an insolvent winding up. The court also said that these judgments should not be recognized, essentially. Okay. Now, what these 2 decisions said back in February was that, let me look at everything. Let me not just look at Article 56A of the Gaming Act, which we went into detail on last time, but let me look at the whole public policy issue. Let me look at it broadly. So
just to sort of summarize a bit, the Maltese courts did not recognize the foreign judgments on grounds of public policy.
Yes, well, on 2 points, on public policy and on Article 56A.
Okay, now I would like to know, what is public policy? And I think even our viewers would like to know why this groundbreaking judgment.
It's a very broad concept.
Yes.
And one can say a bit intangible, a bit fluid. It is what the state, in our case Malta, perceives or is its the direction it wants to take with respect to the industry it wants to pursue, the economy, a broad range of states, the public interest ultimately. It's one can look at it, and these decisions are worth reading for this reason as well, because it is explained during the judgment from the testimony that was brought forward that you elect a government to carry out its manifesto. Its manifesto essentially becomes the public policy of the country as well, to look after the interests of the country, whether the economy is its main interest, whether the public benefit in general. And these judgments were interesting because the judge said, let me take a step back. Let me listen to a broad range of witnesses as well. I'll allow that. I'll allow the state advocate's office to become party to an interested party to the case. And in fact, an expert, a university lecturer, if I'm not mistaken, was brought in to give his interpretation and his explanation of public policy. So it's all outlined within these two decisions. The CEO of the Malta Gaming Authority gave their views. The Austrian lawyers gave their evidence as well. So the judge literally said, I'm going to listen to everything and hear everything. Then the judge carried out an analysis of how these decisions came about, the state of gaming in Austria, that it's monopolistic in its setup. And this is ultimately the issue. Can a Malta gaming operator licensed in Malta operate in Austria?
In Austria.
The Austrian courts believe it cannot, because that is monopolistic, so to speak, is protected, but Malta disagrees based on the principles of freedom of services.
Exactly, because ultimately we're within the European Union, and according to the Treaty of the Functioning of the European Union, there are fundamental freedoms. Two main fundamental freedoms are the freedom to provide services across all EU member states in an unfettered way, and the freedom of establishment. So what we're discussing is that this Austrian judgment is sort of in breach of these fundamental freedoms.
Yeah, that's the way we perceive it. Austria obviously are of a different view because they believe their laws are in line with conveniently so. Again, depends if you're on the player side or if you're on the Malta operator side. So the judge went into all of this. It was very, very detailed 66-page decision, and ultimately, after looking at all of this, looking at how ultimately, in his view, Malta's gaming laws were never challenged as well for being in breach of EU law from any Austrian players, etc. Went into all these different aspects, and at the end of the day, his decision was, look, I could have just said, apply Article 56A and don't take any recognition of these judgments.
Just for our listeners, what does Article 56A state?
Article 56A basically is saying that any action against officers of the company, a gaming operator company, the gaming operator itself as a company, past or present officers, cannot be held liable for these sort of claims based again on the premise of public policy. Like we discussed last time, we need to be careful when referring to this law to ensure that it is not a broadly applied law to protect officers of a gaming operator from any wrongdoing. Exactly. It is specific to these sort of claims because you are challenging the validity of a license, which is, in our view, again, a license issued by the MGA, which is valid within the EU.
Yes.
Now, the judge said, I have this law, black and white. It is very clear. I can apply this law, but I don't just want to stop at applying this law. I want to go into detail. So before getting to this law, I will understand and go into the whole aspect of public policy and how this is recognition and enforcement of these decisions would be in breach of this public policy. And that's the decision on the premise on which he took his decision. But then backed it up by saying, I can still just rely on Article 56A if I want.
Exactly.
So he approached it from two sides and ultimately said, I would come to the same decision, but instead of simply relying on the law, I am doing this entire study to back up my case. It is black on white in his view.
So I get it, this thing of public policy in the public's interest, but I'm missing a link, sort of grounds of public policy. But what's the detail in the sense that the judge wanted to lay out there? Sort of that the gaming industry is a very important industry for Malta. It generates revenue, etc., fundamental to our public interest. Can you explain a bit more?
For what the judge wanted to do, I think is, in my view, is not just rely on one piece of legislation, which, if it is repealed, if it is challenged as a result of EU proceedings, etc., it's a broader scope of what are the interests of Malta,
Yes.
and how Malta is part of the EU, and we go by these principles. Now, if a higher authority is going to overturn what this judge has decided, then it is obviously then the judge will be overruled in that respect, and that decision will be. And it's worth mentioning that these decisions are being appealed at the moment. So these decisions are being appealed. So this is.
We'd need to invite you again.
This is an ongoing story.
Yeah.
That's just a part of it, because these were they're very important decisions. They've given a degree of more certainty within the industry, but we're not at a stage where we have a definite judgment within Malta. We also then need to keep an eye on what's going on within the EU with preliminary references, of which we don't have decisions yet. Hopefully, with respect to the one that came out of Germany, that will be anytime soon now. The one that's coming out of, well, that's to correct myself, that's come out of Malta, the preliminary reference.
Yes,
that's waiting
exactly.
for it, but it's with respect to whether German law is in line with the proper functioning of the.
Just so, once again, for our listeners, a preliminary reference is a sort of question that you ask to the European courts,
Exactly.
and they sort of give, is it an opinion?
Exactly. Pretty much they give an opinion.
It's an opinion, and then it is up to the national courts to enforce that opinion.
Exactly, because it's part of proceedings here in Malta. So then the opinion would come back, and then the judge would take that into consideration on how to move forward.
And are there proceedings at the European Court of Human Rights as well, because of the possible fundamental breach of freedoms?
Not to my knowledge, no. For human rights, no. We've got these two preliminary references to the ECJ, one which is coming out of Austria. So that is also a work in progress. What we have then running in parallel also in Malta, which again, at the moment, everything is the wave is in favor of the operators with respect to enforcing Article 56A. And what we have now is in May, another decree, which we're expecting another decree with respect to the recognition and enforcement of judgments again in Malta, but now we're going a bit more granular, because now they're opening up into, should we make a distinction between certain types of decisions and others coming out of Austria, for example, the EPOs versus default judgments versus judgments that are lost by the operators. So in the previous decisions I mentioned of February, the judge went into whether a decision an appeal needs to be filed once an operator loses the judge. So what they looked at is, okay, the player in Austria filed the case, the operator did not lost the case, but did not appeal it. In order for the gaming operator then to argue that it should not be recognized and enforced in Malta, should they have gone further, but first by appealing it in Austria, as in exhausting the operator's remedies in Austria? And the judge in this case said it is not necessary.
Okay.
Because the gaming operator's point of view was, just speaking quite colloquially, is why throw good money after bad? We know where we're heading. Why appeal a lost case?
Exactly.
So to speak. So that the judge went into that detail as well. That's why it's quite these decisions are detailed. Now in separate proceedings, which are not specifically on these issues, because it is a winding up of a company which could be insolvent. These are also issues that are being raised, because the official receiver's questions in this case is, if I do not need to recognize these judgments and these player claims, then I'm not insolvent, because the company is not insolvent because I do not need to pay them.
Interesting. So it's clear.
So we need clarification on this.
Also, just to clarify, an official receiver is a sort of liquidator during insolvency proceedings appointed by the court, correct?
The official receiver is a department, what is now the IRS within the MBR, which is the government liquidator. So to speak, the official receiver is within the MBR. It's an authority.
Exactly.
So while the court can appoint both the official receiver or can also appoint a private individual as a liquidator in a court winding up. The only difference as of December 2022 in order to be appointed as a liquidator of an insolvent company, pre-insolvency proceedings, or a creditor's winding up, or a court winding up, you need to be a licensed individual, of which there are some 13 in Malta only.
Exactly.
So it's a very small pool. Now,
You're one of them, right?
I'm one of them, yes. Otherwise, I wouldn't be doing a lot of this work. Now, what is very interesting as well with the winding up in court is that when we have these disputes, like we hope to have a decree on in May, I myself have done it recently. I'm a liquidator and a solvent winding up. I try to mediate a solution based on law. As long as I have the shareholders backing a resolution of the shareholders, I can come to an agreement with the creditors or the perceived creditors, because again, the law says they are not creditors, the players, but they argue that they are.
Exactly.
But the law is very broad in the interpretation of creditors in coming to a compromise. So I try to reach a compromise, but I get pushback saying, listen, we disagree with Maltese law, we believe in Austrian law, go ahead and recognize us as creditors. What I then do, and this is what I've done, once I've gotten to a point where there's a stalemate and I can't reach a solution or find a compromise, I go to court. And I've put the matter before the courts, and I've asked the court now to give me a decision on whether player claims are to be recognized as creditors or not. And I've given all these decisions that I've referred to. I've referred to the law as the reasons why I do not believe they are to be recognized as creditors according to law. And I also went a step further and asked the judge with respect to the application of GDPR restrictions in Malta with respect to player claims requesting data as a basis for filing a player claim against the company. So they're using it basically as a pre-discovery procedure, a procedure which is unheard of in Malta, whilst it is in America, for example, but in Malta we do not have pre-discovery procedures. And they try to use this against the company to get the data what they need in order to file a claim against the company.
We'll have to, as I said, we have to follow up on this.
Yes, definitely.
Definitely have another episode, because this is ever evolving. And I think it's one of the most important litigious matters at the moment that's going on. I mean, but having said that,
yes.
Our time is up for today. However, as I said, we'll definitely need to follow up this on and keep on discussing and keep our viewers and listeners abreast, because it's something which is, I guess, fundamental. And I thank you once again for visiting us, and I look forward to our next discussion. Thank you.
Thank you very much.